Each testimony builds a stronger case. Every sharp focus reveals clarity. Learning your legal rights, upholding unyielding justice.
You still haven't told me why you pulled me over, Sheriff.
Ma'am, vehicles like this are often flagged for theft. Just need to verify ownership.
Flagged for theft? I've driven this car for 3 years. It's in my name.
That may be, but someone in your situation driving a car like this raises questions.
She had left home that morning of February 14th, 2025, with the same routine as any other work morning. She had had coffee, had checked the day's schedule on her tablet, had picked up the folder with the documents she would need at court, and had walked out the front door of the house where she lived in that residential neighborhood, with its large homes and leafless February trees against the blue sky of a cold morning. The car she had gotten into was white, was luxury, and was hers, purchased with 23 years of a career in a profession that rewards decades of competence with the kind of financial stability that allows certain choices. She had started the engine, had put on her seatbelt, had pulled out of the residential street toward the highway that led to the courthouse where she had worked for 8 years. It was an ordinary Tuesday morning. There was no reason for it to be anything else. And then the lights of a police cruiser had appeared in the rearview mirror. The officer's body camera had begun recording before he reached the driver's window. This was visible in the timestamp, 10:42 in the morning, on a day in February 2025, and had captured the agent's approach to the white car with that specific image quality that body cameras produce when winter sunlight hits metallic surfaces, slightly overexposed, with colors mildly flattened, but with enough clarity that every detail mattered. What the camera had captured when it reached the height of the driver's window was a middle-aged black woman in a royal blue blazer and gold necklace with her right hand still on the steering wheel. Looking at the officer with that expression, anyone who has ever been stopped without reason immediately recognizes the expression of someone who already knows what is happening before a single word is spoken, and who is calculating in real time how to respond in a way that does not worsen a situation that should not be happening. The woman sitting in that white car was named Dr. Catherine Morris. She was 52 years old, had been appointed federal judge 8 years earlier after a career that had included 15 years as a public prosecutor and 6 years as a constitutional law professor at a university whose name appeared on the country's best law schools lists. She had been appointed through a process that involved Senate review, had been confirmed by vote, and exercised jurisdiction over a federal district covering a considerable geographic area, with a population that included the neighborhood where the officer had turned on his cruiser lights behind her car that February morning. She had spent 8 years applying the law with a precision that attorneys who appeared regularly in her courtroom described in terms that consistently converged around two characteristics: that she was rigorous with evidence, and that she treated everyone who appeared before her with the same demands and the same respect, regardless of who they were. On that February morning, a police officer had decided she needed to prove who she was before she could continue on her way to work. The officer had said there was an irregularity with the vehicle's license plate. That had been the initial justification, though a license plate irregularity, communicated with the technical language officers use when they need an articulable reason for an approach and choose the vaguest available criterion. Catherine had heard that, had looked at the officer with the expression the camera had captured, and had done something the camera had also captured, and that any attorney or judge would immediately recognize as the behavior of someone who knows the process that is about to happen. She had become very still, had kept her hands visible, and had begun processing every word with the attention of someone who knows that every word being said and every word being answered is being recorded, and that that recording will matter. If this is your first time on this channel, welcome. What that body camera captured on that residential street in February 2025 is one of the most extraordinary recordings this channel has ever analyzed, not for the rarity of what happened, but for the specific identity of who was sitting in that car, and for what that identity revealed about how the system fails, even the people who were placed inside it, to ensure it does not fail. Hit subscribe right now and tell me in the comments, do you think a federal judge should have to prove who they are to an officer in an unjustified stop? Tell me down below. The license plate irregularity that had been cited as the reason for the stop would be verified during the subsequent process, and the result of that verification would be one of the most cited elements in legal analyses of the case in the weeks that followed. There was no irregularity. The plate was correctly registered, the vehicle registration was current, the insurance was active, and there was no pending issue of any kind. Associated with that car or that plate in any system, the officer could have consulted before turning on his cruiser lights. What there was a white luxury car being driven by a black woman in a residential neighborhood of large homes on a Tuesday morning, and the camera had captured the approach that combination had produced with enough clarity for the entire world to watch and draw its own conclusions about what had motivated those lights to appear in Catherine Morris's rearview mirror on that Valentine's Day morning. The officer had arrived at the driver's window with that posture body camera's capture with a fidelity that human memory rarely manages to replicate. The posture of someone who had made a decision before getting out of the car and was implementing that decision with the specific confidence of someone who does not expect the decision to be questioned. He had asked for the driver's license and vehicle registration with the tone of someone making a request that presumes immediate compliance. Catherine had opened the glove compartment with deliberately slow and visible movements, had removed the documents, and had handed them through the window with her right hand, while the left remained visible on the steering wheel. That gesture, of keeping the left hand visible while moving the right, was the gesture of someone who had learned, through a combination of legal training and lived experience, that every movement in a police stop has the potential to be interpreted, and that the interpretation can have consequences the movement itself does not justify. The officer had examined the documents for a time the camera had captured as longer than necessary to verify the validity of a driver's license and vehicle registration document. During that time, Catherine had kept her hands on the steering wheel looking forward, and the camera had captured that profile of her. The blue blazer, the gold necklace, the upright posture of someone containing a reaction, while simultaneously processing what is happening and what they will do about it. Other cars had passed on the residential street during that time, some slowing slightly when passing the cruiser with its lights on, the kind of deceleration drivers make when they see a police stop, and that is simultaneously curiosity and caution. None of those cars had stopped. The scene had happened with that quality of public visibility and simultaneous invisibility that defines many of the situations this channel examines. The officer had returned the documents and had asked a question the camera had captured with enough clarity to be transcribed word for word. He had asked what Catherine was doing in that neighborhood. He had not framed the question in any operational context. He had not said there was an incident in the area, or that there was an ongoing search or any other reason that made the question functionally connected to any legitimate policing objective. He had simply asked what she was doing in that neighborhood, with the specific tone of a question that presupposes that the person being asked needs a reason to be where they are. Catherine had responded that she lived in that neighborhood, had pointed in the direction of the street she had left a few minutes earlier. The officer had looked in the direction she had pointed, with an expression the camera had captured, and that anyone watching would describe as the expression of someone who has received information they had not anticipated, and who is still deciding what to do with it. It was at that moment that Catherine had said something the camera had captured, and that had initiated a second phase of the interaction that was qualitatively different from the first. She had said, with that calm the camera had recorded, as the calm of someone who chose each word carefully before opening their mouth, that she was a federal judge and that she needed to know what the legal justification for the stop was because she had not committed any traffic violation and the car's documentation was entirely current. She had said this not as a threat or as intimidation, but as information, the same way any citizen has the right to ask for the justification of a police stop, with the difference that Catherine knew, with a technical precision, that few citizens possess exactly what the law required as the basis for that stop, and exactly what the absence of that basis meant legally. The officer had been silent for a moment after hearing that. The camera had captured that silence with the same fidelity with which it had captured everything else. The mention that she was a federal judge had produced in the officer's behavior a change the camera had documented in enough detail that anyone watching could identify the exact moment it occurred. It had not been a dramatic postural change or an immediate verbal reaction. It had been a subtler change in the speed of subsequent responses, in the frequency with which the officer's eyes had gone to the camera on his own chest, and returned to Catherine in the slightly different quality of the tone he had used in subsequent sentences compared to previous ones. It was the change of someone who had received information that altered the situation's calculation, but who had not yet completely decided how to integrate that information into what they were doing. Catherine had observed that change with the attention of someone who had spent 8 years observing how people behave when processing new information in a context of pressure, which was essentially what happened in a courtroom every day, and had continued waiting with her hands on the steering wheel. The officer had asked Catherine to wait and had returned to his cruiser. He had been in the cruiser for 9 minutes, according to the body camera timestamp that had continued recording throughout that time. During those 9 minutes, Catherine had stayed in her car with the engine running and had done something the camera had not captured because it had happened inside the vehicle, but that she would later describe with a precision that made the scene completely visible without any image. She had picked up her phone, had opened the Notes app, and had begun typing. She had typed the cruiser number she had seen in the rearview mirror when the lights had appeared. She had typed the time. She had typed the exact street. She had typed every word of the interaction up to that point that she could remember with enough precision to trust. And she had typed the question the officer had asked about what she was doing in that neighborhood in quotation marks, because that specific question had been sufficiently precise in its inadequacy to merit exact preservation. The officer had returned from the cruiser after 9 minutes, with a change in posture the camera had captured, and that was different from the posture with which he had first arrived at the window. There was in him now something that was not exactly retreat, but was adjacent to it. The posture of someone who had made a consultation during those 9 minutes that had produced enough information to alter his assessment of the situation without him having yet decided how to articulate that alteration. He had told Catherine that the plate had been verified, and that everything was in order. He had said this without mentioning what the verification had found or failed to find, without explaining why a 9-minute verification had been necessary for a document that was completely regular, and without answering the question Catherine had asked before he returned to the cruiser, the question about what the legal justification for the stop was. Catherine had noted the absence of that answer with the precision of someone who had spent 8 years in a profession where the difference between what was said and what was asked was frequently the most relevant element of any interaction. She had asked the question again, not aggressively or with the tone of someone looking for a confrontation, with the same calm that had characterized every moment of the interaction up to that point, and that the camera had captured as the calm of someone who had made a decision about how to behave before the stop began, and who was maintaining that decision, regardless of what was being said or done around her. She had asked the officer to describe the specific traffic violation or observable behavior that had motivated the stop, because without an answer to that question, the stop had no legal basis, and she needed to understand whether what had happened had been a mistake or something different from a mistake. That specific formulation, the distinction between a mistake and something different from a mistake, had been captured by the camera and had been analyzed repeatedly by legal commentators in the weeks that followed as an example of language that was simultaneously precise in its technical meaning and absolutely clear in what it was communicating beyond that technical meaning. The officer had responded that he had thought the plate appeared irregular when he had passed the car. Catherine had asked what specifically had appeared irregular. The officer had said the angle had seemed different. Catherine had been silent for a moment after hearing that, a silence the camera had captured and that anyone who had watched a trial would recognize as the silence that precedes an observation that will be precise. She had said that license plates had angles because they were mounted on brackets that had angles, and that her plate's angle was the standard factory installation angle that had been there since she had purchased the car. She had said that and then had been quiet again, leaving. The officer's response to occupy the space she had created. The officer had not filled that space with anything the camera could record as a substantive response. There were other houses visible in the camera's background throughout that entire interaction, the large homes of the residential neighborhood where Catherine lived, and where the officer had decided that a white luxury car driven by a black woman justified turning on the cruiser's lights. That framing detail, the neighborhood in the background, had been noted by several of the commentators who had analyzed the video when it became public, because it added a layer of context to the scene that made the question about what Catherine was doing in that neighborhood even more revealing than it already was. She was not in a different neighborhood from her own. She was on the street she had left that morning, on her way to work, in a car she had purchased, in a neighborhood where she had been paying property taxes for years. The question about what she was doing, there was a question about the right to presence in a space that was specifically her space, and the camera had captured that question with the houses of that space visible in the background, with a documentary completeness that no screenwriter could have deliberately constructed. A second officer had arrived during the interaction, dispatched by the first after he had returned from the cruiser, and had parked behind the original cruiser with its lights also on. The arrival of the second officer had been captured by the first camera, and had added an element to the scene that attorneys who would analyze the case would describe as disproportionate escalation, because the stop of a supposedly irregular license plate, which had been verified and had resulted in nothing, had produced two cruisers on a residential street with lights on a Tuesday morning. The second officer had stayed beside his cruiser, observing the interaction without approaching. Catherine's car, a position the camera captured in the background, and that had the visual effect of making the scene larger and more formal than any available justification could explain. Catherine had looked at the second car in the mirror and had returned to looking at the first officer with that expression the camera had captured from the beginning, and that had not changed throughout the entire interaction. She had said she was going to need the officer's full identification number and the stop report number because she was going to file a formal complaint. She had said this not as an ultimatum, but as information about what was about to happen, the same way she had said she was a federal judge, as relevant data that the other party in the interaction had the right to have. The officer had provided the information. Catherine had typed it into the phone, which still had the Notes app open from the period when she had been waiting in the cruiser. And she had put the phone back in the cup holder, had placed her right hand back on the steering wheel, and had waited for the officer to say whether she was free to go, because she knew she needed to hear that explicitly before putting the car in motion, because the camera needed to capture that moment too. Catherine had arrived at the courthouse 23 minutes late that morning of February 14th. She had parked in the space reserved for judges, had picked up the folder with documents from the back seat, and had entered through the court personnel access with that posture that people who worked with her described as her posture on any day, upright, direct, with no external sign that that morning had been different from any other morning. The hearing that had been scheduled for 10 had been rescheduled for 11 by the court clerk when it became clear Catherine would not arrive on time, and the attorneys who had waited in the hearing room had been informed only that there was a delay without additional explanation because Catherine had instructed the clerk to that effect when she had called from the car during the 9 minutes she had waited for the officer to verify a plate that had no irregularity. She had conducted the day's hearings with the same precision as any other day. The attorneys present that morning had not noticed anything different in Catherine's behavior during the hearings, which was itself a relevant data point about the specific quality of control she had exercised over that morning's experience. The capacity to enter a courthouse after having been stopped without justification on her own street, and to conduct hearings with the objectivity the function required without letting one experience contaminate the other. It had been only at the end of the day, after the last hearing had concluded and the court staff had left, that Catherine had sat in her chambers and had made the calls she had decided to make since that moment in the stopped car when she had begun typing in the Notes app. The first call had been to the county police department director, not to a subordinate or to a service line, but directly to the director, whose direct number Catherine had because she exercised jurisdiction over cases involving that department frequently enough for the direct number to be operationally relevant information. She had described the incident with the factual economy of someone who had spent decades doing exactly that, identifying the relevant elements of a situation and communicating them in the sequence and with the level of detail that made the situation comprehensible without unnecessary embellishment. She had given the officer's identification number, the cruiser number, the body camera timestamp she had discreetly consulted during the stop, the question about what she was doing in that neighborhood with the exact words she had typed in the Notes app, and had said she expected the body camera recording to be preserved and that it would be available when formally requested in the days that followed. The director had listened without interruption, had asked 2 questions at the end, both factual, about the exact time and location, and had said he would verify personally. That commitment to personal verification in a call received. At 6 in the evening on a business day, had been the first indicator that the department had made an immediate assessment of the seriousness of what had been reported and had decided that the appropriate response was personal and direct rather than delegated. The second call had been to an attorney specializing in civil liability of public agents with whom Catherine had worked in prior cases in different capacities and who had answered on the first ring when he had seen her name on the screen. He had listened to the account with the attention of someone simultaneously evaluating what they are hearing as a story and what they are hearing as a case, and had said at the end that the element of the question about what she was doing in that neighborhood was, in his words, the element that transformed a documentable discriminatory stop into a documentable discriminatory stop with intent stated out loud and captured on camera. The department had initiated an internal investigation the following day, which was a response speed that those who followed police conduct cases described as unusual, and that had been attributed to two factors that rarely coexisted in a case of that kind. The first was Catherine's identity, because a formal complaint from a federal judge about a state officer's conduct created an institutional dynamic that did not exist when the complaint came from a citizen without institutional position, not because a complaint from a citizen without position should carry less weight, but because the operational reality of departments was that complaints from people with institutional power produced faster responses regardless of any formal policy about equal treatment of complaints. The second factor was the body camera, which had been recording since before the officer reached Catherine's window and had captured every moment of the interaction with a completeness that made any alternative version of events impossible to construct credibly. The internal investigator who had been assigned to the case had watched the complete recording on the first day of the investigation, had prepared a complete audio transcript, and had identified 4 specific moments he had marked as priority analysis points. The first was the initial stop, which the recording showed had occurred without any visible traffic violation or observable behavior that could have motivated the decision to turn on the cruiser lights. The second was the question about what Catherine was doing in that neighborhood, which the recording captured with enough clarity to be transcribed and that had no articulable connection to any legitimate policing objective. The third was the license plate angle justification, which had been presented after 9 minutes of verifying a document that had no irregularity and that the investigator had described in his notes as the weakest justification he had encountered in a stop report in 18 years of internal investigations. And the fourth was the arrival of the second officer, which had escalated police presence in a situation that had not justified the presence of the first. The video had become public 12 days after the stop, not through any action by Catherine or her attorneys, but through a public records request made by a reporter who had received a tip about the incident from a source inside the department who had watched the recording during the first days of the internal investigation and had made the decision that people inside institutions sometimes make when they see something they believe the public needs to see. The request had reached the department at a moment when the internal investigation was still ongoing and when the department had not yet made any formal decision about what to do with the officer involved, which meant that when the video had been made available in response to the public records request, it had been made available in a context where no resolution had been announced, and where the contrast between what the recording showed and the institutional silence about that content had been immediately and widely noted. The reaction to the video had followed the pattern that recordings of that kind produce when the evidence is sufficiently clear, and when the central element of the scene contains something that transcends the usual divisions of who tends to align with which position in police conduct cases. The question about what Catherine was doing in that neighborhood had functioned in that recording the way the officer's question to Ayla at the IHOP had functioned in the body camera of that case, as the moment that condensed in explicit language the assumption that had motivated the entire interaction in a way that made it impossible for anyone watching to argue there was another interpretation available. There was not. The camera had captured an officer asking a black woman what she was doing in the neighborhood where she lived, and had captured that on a street whose large houses were visible in the background, and had captured Catherine's response saying she lived there, and had captured the officer's silence after that response. Any analysis that attempted to construct an alternative narrative needed to begin by explaining that specific sequence, and there was no available explanation that held up. Civil rights organizations had issued statements in the first 48 hours after the video's publication. Bar associations had issued statements. Judges' associations had issued statements, some with language that was unusual in its specificity, naming the officer and describing the behavior captured in the recording with a directness that kind of organization normally avoids in public statements about individual cases. Elected representatives had called for independent investigations, and there was a category of reaction that had been perhaps more widely cited than any of those institutional statements, which was the reaction of attorneys and judges across the country who had shared the video, with comments that touched on a dimension that institutional statements did not fully capture, the dimension that what had happened to Catherine was what happened to black citizens who were not federal judges in similar situations, without a camera, without institutional position, and without the precise legal knowledge Catherine had applied in every second of that interaction. That specific angle had been what had given the case a resonance that went beyond outrage at the treatment of a federal judge, which would have been sufficient on its own, but that had created a broader conversation about what Catherine's experience revealed, about experiences that were not documented on body camera and were not conducted by people with the training to respond the way she had responded. Catherine had said in one of the few statements she had made during the period prior to the case's resolution that what had happened to her had happened because of who she was, and that there were people who lived the version without camera of that experience regularly without the resources to do what she was doing about it. That statement had circulated widely and had been cited with a frequency that indicated it had resonated in a way that longer and more elaborate statements frequently do not resonate, because it had said in 2 sentences what many longer analyses tried to say in many more words. The department had announced the conclusion of the internal investigation 28 days after the stop, which was also 16 days after the video had become public. The conclusion had been that the officer had violated departmental stop protocols by having no articulable justification based on objective observation before turning on the cruiser lights, had violated conduct protocols by asking questions that had no connection to any legitimate policing objective, and had escalated the situation disproportionately by calling reinforcements in a situation that had not justified the initial presence. The investigation had recommended dismissal. The director had agreed with the recommendation and had announced the officer's dismissal in the same statement that announced the investigation's conclusion, a timing choice that had been read as a signal that the department had decided that the speed of resolution was as important as the resolution itself. The civil lawsuit had been filed 2 days after the dismissal announcement, and the timing had been deliberate in the same way that the timing of several prior elements had been deliberate, as the result of a strategy that had been thought through from the first days after the stop, with an attention to detail that reflected what happens when someone with Catherine Morris's training and experience directs that competence toward a situation that had happened to them. The lawsuit named the officer individually, the department as an institution, and the county as the entity responsible for supervising the department, and had been constructed with a specificity that attorneys who analyzed it described as a document that had been prepared by someone who knew exactly what a judge looks for in a lawsuit, because they had spent 8 years being that judge. The agreement was signed 43 days after that Valentine's Day morning, at a speed that had surprised even the most experienced attorneys following the case, because lawsuits against police departments rarely resolve in less than 2 months, even when the evidence is clear, and even when the dismissal of the agent involved has already been announced. The speed had been attributed by people close to the negotiations to a factor that was simultaneously obvious and rarely articulated with that clarity. The county had assessed that each additional day without resolution was a day the video continued circulating. The department's name continued appearing in legal analyses and discussions about police conduct, and the distance between what the recording showed and any defensible narrative continued being the central element of every conversation about the case. The rapid resolution had not been institutional generosity. It had been calculation. The financial amount of the agreement had been substantial, confirmed by sources close to the process as being among the largest paid by the county in individual civil rights cases, with a specific component that had been negotiated at Catherine's insistence and that had not been seen in prior department agreements. A portion of the amount had been designated as a fund dedicated exclusively to training agents on stops in residential neighborhoods, with an oversight committee that included representatives from community organizations, and that had authority to approve the curriculum before implementation and to audit execution afterward. That condition had transformed part of the money the county had paid to resolve the lawsuit into a mechanism that existed specifically to reduce the likelihood that the situation that had generated the lawsuit would repeat itself, and had been described by civil rights specialists who analyzed the agreement as one of the most creatively constructed conditions they had seen in a case of that kind. The officer had been dismissed before the agreement was signed as a result of the internal investigation, and the dismissal had included a notation in the employment record that prevented rehire in any law enforcement capacity in the state. The union had filed an appeal that had been denied on second review after the arbitrator had watched the complete recording and had concluded in his findings that the question about what Catherine was doing in that neighborhood had no available operational interpretation that made it part of any legitimate police protocol, and that the absence of any observable justification for turning on the cruiser lights was documented by the agent's own body camera in a way that made the defense based on operational discretion impossible to construct without contradicting what was recorded on that camera. The union had attempted a third instance. It had been denied with language even more direct than the second. The institutional conditions of the agreement had been more extensive than the financial conditions in terms of pages negotiated, which was an indicator of the priority Catherine had given from the beginning to outcomes that existed beyond her individual case. There was a complete revision of stop protocols with documentable criteria that each agent would need to be able to articulate before turning on a cruiser's lights, not after the stop, as had been the case with the license plate angle justification, but before, with registration in the dispatch system of what the justification was at the moment the decision was made. There was a system of stop pattern analysis by agent and by geographic zone that would automatically identify statistical anomalies that could indicate systemic discriminatory behavior before individual cases reached the stage of formal complaint. And there was a condition that had been the most debated in negotiations, and that Catherine had described in one of her meetings with the attorneys as the most important of all. Any agent who asked a question during a traffic stop that had no articulable connection to the registered justification for that stop would be subject to automatic review without need for formal complaint from the stopped party. The case had produced consequences that spread beyond the county in ways that had become documentable in the months following the agreement. Departments in other states had revised their stop protocols citing Catherine's case as a reference. Law schools had incorporated the recording into constitutional law and civil rights courses as an example of documentation of a discriminatory stop with direct evidence. Police training organizations had developed curriculum materials based on the analysis of the 4 moments the internal investigator had identified as failure points, not because Catherine's case was unique, but precisely because it was not, because the patterns the camera had documented were patterns that existed in stops that were not recorded or that were recorded, but did not reach the level of public attention this case had achieved. Catherine had returned to the courthouse the day after the agreement was signed, had conducted the scheduled hearings with the precision of any other day, and had responded to the questions of journalists waiting outside the courthouse with a brevity that had frustrated some, and that had been exactly right according to others. She had said the agreement was fair, and that the institutional conditions were the outcome she had sought from the beginning. She had said the body camera had documented what it had documented, and that the system had functioned the way it should function when evidence and determination are simultaneously present. And she had said, before going back into the courthouse, that the following morning she would drive the same car, down the same street, at the same time, because that was the way to work, and because no stop on a February day was going to change the route she took to work. She had entered through the court personnel access without looking back. At 10:42 the following morning, the white car had passed down the same residential street with the large houses and the trees still leafless in the late winter, and there were no cruiser lights in the rearview mirror, just the road.
I need to see your papers. Are you a U.S. citizen?
Yeah, born in Chicago.
What's this about? I'm asking a simple legal question. What's my violation? What have I done wrong?
Just show me the goddamn papers.
The question he asked was the simplest possible. He wanted to know what his violation was. He wanted to know what he had done wrong. It was not an aggressive question or a provocation. It was the direct question of a man who had spent decades of his life serving a country that was now, in a parking lot on a sunny day, demanding that he prove he had the right to exist in it. The agent in front of him did not answer immediately. The second agent in the tactical vest stood in the background watching, and the body camera that had begun recording before any word was spoken captured every second of that scene with the precise indifference of a device that does not know what it is documenting but would document anyway, because that is what cameras do. What that camera had documented in that parking lot that day would be enough to change everything that came after. The man standing in that parking lot with that question in the air had served in Vietnam. He had been deployed at 18, had spent 14 months in a theater of operations that produced in a specific number of people who experienced it a kind of memory that does not dissolve with time, but integrates in ways that each person who carries it manages as best they can. He had come home with honors, had rebuilt a life with the determination of someone who learned that rebuilding is what you do when what existed before can no longer be recovered, and had reached 68 years of age with the kind of presence that decades of experience produce in people who pay attention to what life teaches. There was in that posture, even in the adversity of that parking lot, something the camera captured, but that no camera can fully capture. The specific dignity of someone who knows who they are, regardless of what anyone else in that moment is saying or doing. The agents who had approached him in that parking lot belonged to an immigration and customs enforcement unit operating in that region of the state. They had arrived in 2 cars, had positioned themselves in a way the body camera captured as the tactical configuration of a planned operation and not a casual encounter, and had approached the man while he was in the parking lot with a list of items he had purchased at the store beside it still in his hand. There were eggs in the bag. There was bread. There was the kind of purchase a person makes when stocking the kitchen for an ordinary week. And there were 2 federal agents asking him to prove who he was, because his appearance had led someone to a conclusion about his citizenship that the reality of his history disproved with a completeness that would be documented in detail in the weeks that followed. The man's name was Leonard. He was 68 years old, had been born in the state where he was now standing in that parking lot, had received his Vietnam draft notice at 18, like any other American citizen of his generation who had reached that age at that specific historical moment, and had served with a distinction recorded in military documents that existed in a federal archive that any government agency could access, with a query that would take less time than the interaction happening in that parking lot. After military service, he had worked for 32 years at a distribution company, had retired with the pension that work had produced, and had spent the subsequent years in a routine that included the grocery store every Thursday morning, because Thursday was the day the sales changed, and Leonard had developed over decades the kind of domestic efficiency that comes from paying attention to details most people do not think are worth attention. If this is your first time on this channel, welcome. This story has a specific layer that separates it from other cases this channel has examined, because what the ICE agents did in that parking lot did not happen in a vacuum. It happened in the context of a specific policy, in an operation with defined targets, and the questions it raised went beyond that parking lot and that day. Hit subscribe right now and tell me in the comments. Can you imagine being a war veteran and having to prove citizenship to government agents in your own country? Tell me down below. The body camera had captured Leonard's question with a clarity that made any argument about what had been said impossible. 4 words that were also 4 questions. What was the violation? What had he done wrong? The agent in front of him had responded with language the camera had recorded, and that Leonard's attorneys would analyze repeatedly in the weeks that followed, language that avoided answering the question while creating the appearance of responding, that used terms like routine verification and operational protocol to substitute for the answer that did not exist, because there was no answer that held up. Leonard had listened to that language with the expression the camera captured as the expression of someone who recognizes when a non-answer is being packaged in words that sound like an answer. He had served in an army that used that kind of language. He knew the difference between communication and cover. And the question he had asked, what was the violation, what had he done wrong, remained in the air unanswered, because the true answer was that there was no violation and nothing wrong beyond the conclusion someone had formed about who he was before verifying any fact. Leonard had arrived at that grocery store parking lot at 10:17 on that Thursday morning, as he had done on practically every Thursday for the past 6 years since he had retired and established the routine that retirement allows when you no longer need to organize time around an external schedule. He had parked the truck in the same spot he usually parked, had taken the list he had written the night before on a notebook page that he folded and placed in his shirt pocket, and had done the shopping with the methodical precision of someone who knows every aisle of that specific store and knows exactly where each item is without needing to search. He had spent 23 minutes inside the store, had paid at the register with the same employee who served him frequently enough to recognize him by name, and had come out through the automatic doors with 2 bags and the list crossed out entirely because he had found everything he had planned to find. The agents had arrived at the parking lot some minutes before Leonard came out of the store. There were 2 unmarked vehicles positioned in ways that the body camera one of them was carrying had begun recording before Leonard appeared through the automatic doors. This was visible in the recording and was a detail that Leonard's attorneys would identify as relevant. The agents were positioned and recording before Leonard came out, which meant the approach had not been the result of spontaneous observation of behavior in the parking lot, but had been planned before Leonard appeared, which raised a question that would be central to the lawsuit, the question of how Leonard had been identified as a target before he was in the parking lot, and what had underpinned that identification. The agent who had made the initial approach was named, according to records that would be obtained during the discovery process, Supervisory Agent Daniel Walsh. Walsh had approached Leonard shortly after he came out through the automatic doors with the bags, had identified himself as an ICE agent, and had asked for identity documentation. Leonard had stopped, had looked at the agent, and had asked that question the camera captured, and that would become the most shared caption of the video when it reached the public. He had asked what his violation was, what he had done wrong. Walsh had responded that it was a routine verification and that he needed to see a document. Leonard had said he was American, that he had been born in that state, and had asked whether there was any law that required an American citizen to carry proof of citizenship to do grocery shopping. That question had hung in the air for a moment before Walsh responded that he just needed to verify identity and that it would be quick. What Leonard had been carrying in his wallet that day was what most people carry in an ordinary wallet: his driver's license, some cards, a health insurance card, and a veteran's military service card he had carried since receiving it. After military service 50 years earlier, and that had become so integrated a part of that wallet's contents that Leonard sometimes forgot it was there, until a situation like that, one made it the most relevant object of everything he possessed. He had removed the wallet from his pocket, had shown the driver's license first because that was what most people showed when someone asked for identification, and Walsh had examined the document for a moment before saying he needed something that confirmed citizenship status. Leonard had looked at the agent with that expression the camera captured and had removed the veteran's card from the wallet. The veteran's card had been examined by Walsh with the second agent who had approached during that time. The two had exchanged a few words in low voices that the camera's audio had captured with insufficient clarity for transcription, but with enough to establish that an exchange was occurring. Walsh had then told Leonard he needed to verify the information in the system and that it would take a few minutes. Leonard had asked whether he was being detained. Walsh had said no, that it was a voluntary verification. Leonard had responded with the precision of someone who knows the difference between the legal categories Walsh was using, had said that if it was voluntary, then he was ending his cooperation and continuing with his day. Walsh had said it would be better for Leonard to cooperate. That phrase, that it would be better for Leonard to cooperate, had been captured by the camera with enough clarity to be transcribed, and was the phrase Leonard's attorneys would later describe as the moment of voluntary verification had become implicitly coercive, because the suggestion that it would be better to cooperate in an interaction the agent had just described as voluntary created a pressure that made the voluntary character of the interaction a fiction. Leonard had stayed in the parking lot, not because he had agreed that it was better to cooperate in the way Walsh had suggested, but because he had made a calculation that any black man of his generation would understand without need for explanation. There were 2 armed federal agents in a parking lot on an empty weekday morning. There was a camera recording. And there were decades of experience that taught that the difference between a situation that resolves without incident and a situation that resolves otherwise frequently depended on decisions made in the first minutes about how to respond to what was being done. Leonard had stayed, had kept the bags in his hand, and had continued asking questions with that direct precision of someone who knows that every question and every answer is being recorded and that it matters, even when it is not yet possible to know exactly in what way it will matter. The system verification had taken 17 minutes. 17 minutes during which Leonard had stood in the parking lot with the grocery bags in his hand in the sun of a summer morning, while Walsh operated a tablet and the second agent remained positioned a few meters away in a configuration the camera captured with enough clarity that anyone watching would understand. There was nothing voluntary about Leonard's presence in that parking lot, regardless of the language Walsh had used to describe it. Other store customers had passed through the parking lot during those 17 minutes. Some glancing briefly toward the scene, others looking away with the kind of artificial hurry people develop when they see something that discomforts them, but that they do not know how to process. None had stopped, none had asked anything. The scene had happened with the specific invisibility of things that occur in broad daylight, but that context makes difficult to intervene in. During those 17 minutes, Leonard had asked 3 more questions the camera had captured. He had asked Walsh's full name and the agent identification number, information Walsh had provided after a hesitation the audio had recorded as a pause of perhaps 4 seconds before the response. He had asked on what legal basis the verification was being conducted, specifically which statute or regulation authorized ICE agents to approach American citizens in grocery store parking lots and demand proof of citizenship without any specific probable cause. Walsh had responded with a reference to general operational authority that had cited no specific statute and that Leonard had immediately identified as a non-answer, saying he had asked for the legal basis and not a description of the agency's general authority. He had also asked whether Walsh's supervisor was available to be contacted at that moment. Walsh had said he was the supervisor in the field on that operation. The verification result had arrived on Walsh's tablet 17 minutes after Leonard had been approached. The camera had captured Walsh looking at the tablet, had captured the expression that crossed his face at that moment, and had captured what he said next, which was the kind of sentence that reveals, by the way it is constructed, that the person saying it understands there is a problem with what was being done, but is not yet ready to name that problem directly. Walsh had said that Leonard's information had been verified and that he was free to continue his day. He had not apologized, had not explained what the verification had found, had not acknowledged any inadequacy in the approach. He had simply declared that Leonard was free, as though the freedom of a 68-year-old man to do grocery shopping in the city where he was born were something that needed to be declared by a federal agent after 17 minutes of verification. Leonard had stood still for a moment after hearing that. The camera had captured that moment with the detail cameras capture when something is happening that has no movement but has weight. Then he had said something Walsh had clearly not expected and that the camera had recorded with enough clarity to be transcribed word for word. He had said he wanted Walsh's full name again, the operation number being conducted, the second agent's identification number, and the location of the ICE office responsible for that operation, because he had served in that country for 14 months in Vietnam, and was not going to go home and forget what had happened in that parking lot as though it had not happened. Walsh had provided the information with that same 4-second hesitation that had characterized the first time his identification number had been requested. And Leonard had retained everything mentally with the precision of someone who had learned decades earlier that information retained at the right moment is frequently the only protection available. What the verification had found, and that would become public during the discovery process of the subsequent lawsuit, was that Leonard did not appear in any ICE record as an investigation target. There was no deportation order associated with his name. There was no ongoing immigration status verification process related to him, and that the Social Security number associated with his name identified him unambiguously as an American citizen born in that state with decades of documented tax, Social Security, and military service records in federal archives that any government agency could access. The verification had confirmed in 17 minutes that Leonard was exactly who he had said he was from the first second of the interaction. What it had not explained, and what the lawsuit would attempt to establish with the precision the available evidence permitted, was why that verification had been necessary in the first place. What had placed Leonard on an approach list for an ICE operation in a grocery store, parking lot in an American city on a Thursday morning? There was an answer to that question that emerged from documentation obtained during the discovery process, and that was simpler and more disturbing than any complex operational explanation could be. The operation Walsh was part of had been conducted in that specific neighborhood, based on a profile that internal documents described as identification of individuals with phenotypic characteristics consistent with undocumented populations of Latin American origin. Leonard had no Latin American origin. There was nothing in his history, his appearance, his behavior, or any other observable characteristic that connected him to that profile beyond one characteristic. The documents did not mention explicitly, but that the sequence of events made inferable with a clarity that Leonard's attorneys would describe as the best documented inference they had constructed in a case in many years of practice. Leonard had been approached because he was black, because he was in a neighborhood where the operation was active, and because someone had made a decision about who he might be before verifying any fact about who he was. Leonard had arrived home that Thursday with the grocery bags and with something more he had brought from that store's parking lot. The absolute clarity that what had happened that morning was not something a complaint call to a general customer service number would resolve. He had put the groceries away with his usual meticulousness, had placed the eggs in the refrigerator, had folded the bags and stored them in the drawer where he kept bags because Leonard was the kind of person who reused bags, and then had sat at the kitchen table with a notebook and had begun writing. He had written the names he had memorized in the parking lot, Walsh and the identification number, and the second agent's number, and the description of the tablet and the exact time he had noted when Walsh had arrived, and the approximate time at which he had been released. He had written all of this in the organized handwriting of someone who had learned decades earlier, in military service, that precise records save, lives in contexts where the official version of events can diverge from what actually happened. The call he had made that afternoon had not been to any complaint line or to any elected representative. It had been to a man named Gerald, who had served with Leonard in Vietnam, who had returned to the same city, and who had spent the last 20 years working as a paralegal at a civil law firm after completing law school at 52, with the specific determination of someone who decides late that they need tools they did not have. Gerald had listened to the complete account without interruption, had asked 3 questions at the end, had said that Leonard needed an attorney specializing in 2 fields simultaneously, civil rights and federal litigation against government agencies, and that he knew exactly the right person. He had also said that Leonard needed to do one thing before anything else: formally request the body camera recording of the agents present in the parking lot before the mandatory preservation deadline expired. Leonard had asked what that deadline was. Gerald had said it varied by agency and jurisdiction, and that the safest answer was to act as if it were tomorrow. The formal request had been sent the following day, drafted with Gerald's assistance and addressed to the ICE office responsible for the operation, with a copy to the Inspector General's Office of the Department of Homeland Security. That copy to the Inspector General had been a strategic decision that the attorney who would take on the case 2 weeks later would describe as one of the most intelligent he had seen a client make before having legal representation, because it had created a record that the request had reached a supervisory level that made any subsequent loss of the material much more difficult to treat as accident or technical failure. The request had identified the agents by name and identification number that Leonard had memorized, had specified the time and location of the incident, had described the requested material with enough precision that there was no ambiguity about what was being asked, and had established that the material was needed as evidence in connection with a formal complaint about federal agent conduct that was being prepared. The attorney who took on the case was named Victor Reyes, had 46 years of federal litigation experience, and had conducted lawsuits against government agencies with enough frequency to have developed the kind of mental map of those agencies' defense mechanisms that only builds through years of repeated encounters with the same tactics in different contexts. When he had watched the recording for the first time, he had been silent for a few minutes after the video ended before speaking. He had said there were 2 elements in that video that, individually, would support a solid lawsuit. Together, he had said, they created something that, in his words, was difficult to defend by any attorney who needed to make that defense while looking at that video at the same time as looking at a jury. The first element was Leonard's question. What was the violation? What had he done wrong? And the absence of any answer that held up. The second was the veteran's card, which had been examined by the agents and that established with an absolutely devastating symbolic economy that the man they were treating as a suspect of illegal presence in a country had served that country with weapons in hand, while many of his contemporaries had found ways not to do that. The lawsuit had been filed in federal court with allegations covering 4 distinct categories. The first was unlawful detention because the interaction had been described as voluntary by Walsh, but had been conducted in a way that made Leonard's departure implicitly impossible without the consequences that the suggestion it would be better to cooperate had communicated. The second was racial discrimination by a federal agent, grounded in documentation obtained during the discovery process that had revealed the operation's profile and the absence of any criterion beyond physical appearance that could explain Leonard's approach. The third was violation of Fourth Amendment constitutional rights because the verification had occurred without established probable cause and without any genuine consent that the coercive context of the interaction could have produced. And the fourth, which had been the most debated internally before being included, was specific harm to a war veteran whose identity as an American citizen had been questioned by agents of the government he had served, an allegation that had no direct precedent in jurisprudence, but that Victor had argued with sufficient theoretical basis to be included as an alternative the court could consider independently of the other 3. The agency had responded to the lawsuit with the kind of response that government agencies produce when they need to defend actions that available evidence makes difficult to defend. They had invoked operational discretion, had argued that Walsh had acted within the limits of his authority as a federal agent, and had attempted to frame the interaction as the result of a good faith error in an operation with legitimate objectives. That line of defense had collapsed in distinct phases as the discovery process had revealed the operation's internal documents, the profile criteria used, and the history of approaches the operation had conducted in that neighborhood in the weeks before and after the incident with Leonard, a history that had shown a pattern that made the characterization of an isolated good faith error progressively impossible to maintain, with documentary evidence pointing in the opposite direction. The operation's internal documents obtained during the discovery process told a story that was more detailed and more problematic than any narrative the agency had publicly produced about the incident with Leonard. The operation had been authorized 6 weeks before the day Leonard had left the store with his grocery bags, had been designated with an internal code the documents used consistently, but that Leonard's attorneys had identified as irrelevant to the lawsuit, and had been described in the authorization documents as an enforcement initiative focused on geographic areas with high concentrations of undocumented populations of Central American and South American origin. That geographic and demographic description had been the basis on which agents had been instructed to identify approach targets, and the training documents associated with the operation had described the identification criteria in a way that specialists consulted by Leonard's attorneys had evaluated as functionally equivalent to racial profiling authorization, because the observable criteria agents had been instructed to use in identifying targets were phenotypic criteria that any honest analysis would recognize as proxies for race and ethnicity and not as objective indicators of immigration status. Walsh had been deposed 6 weeks after the filing of the lawsuit. The deposition had lasted 4 hours and 20 minutes, and had been conducted by Victor with a methodology that observers present described as the methodology of someone who had prepared each question with full knowledge of what the most likely answer would be and how each answer related to the body of documentary evidence already in Leonard's attorney's possession. Walsh had responded with the consistency of someone who had been prepared by the agency's legal team, but had encountered an obstacle that legal preparation can never completely eliminate when documentary evidence is sufficiently specific. There were moments when the answer preparation suggested and the answer the documents made defensible were different answers, and at those moments the testimony had produced inconsistencies that Victor had documented with precision and that had become a central part of the evidence archive. The most revealing question of the deposition had occurred in the 3rd hour, when Victor had asked Walsh to describe the specific criterion that had motivated the approach to Leonard in that parking lot. Walsh had said he had observed behavior consistent with the operation's profile. Victor had asked him to describe that behavior specifically. Walsh had said that Leonard had been standing in the parking lot for a time, that had seemed inconsistent with someone who had done grocery shopping. Victor had then presented the store's point-of-sale system, records showing the exact time Leonard had paid and left. and had calculated out loud the time between Leonard's exit through the checkout and Walsh's approach, which had been approximately 90 seconds. He had asked whether Walsh considered that 90 seconds between leaving a store and being approached by federal agents who had already been positioned in the parking lot before Leonard's exit constituted a time inconsistent with someone who had done grocery shopping. Walsh had been silent for perhaps 8 seconds before responding that there were other factors. Victor had asked him to list those other factors. Walsh had listed 2 that the operations documents contradicted and had fallen silent after the second. The video had reached the public during that period, not through any deliberate strategy of Leonard's attorneys, but through a process that had begun when a journalist covering EACE had obtained information about the lawsuit's existence and had requested access to the case's public records, which included references to the body camera that by that point had already been preserved and transferred to Leonard's attorney's control through the appropriate legal mechanisms. The recording had been described in enough detail in an initial article that demand for the complete video became immediate and intense. When the video had eventually been made available as part of the case's public records, it had accumulated more than 12 million views in 72 hours, a number that had surprised even the platforms where it had circulated, and that had transformed Leonard's case into a reference point in discussions about ICE practices that had been occurring in policy circles, but that the video had brought to a dramatically wider audience. The public reaction had created pressure on the agency that had operated in parallel with the legal pressure, and had interacted with it in ways that legal strategists on both sides had attempted to calculate with limited precision, because that kind of interaction between public pressure and legal process rarely follows predictable models. Veterans organizations had issued statements that had been particularly effective in terms of media coverage because they had combined the language of service and sacrifice with a specific criticism of the agency that was difficult to dismiss with the framings the agency normally used to respond to criticism of its practices. Elected representatives had called for investigations. The Inspector General of the Department of Homeland Security had opened an independent review of the operation that had been conducted in that neighborhood, a review that had occurred in parallel with Leonard's lawsuit, but that had been initiated by the copy of the evidence preservation request that Gerald had advised Leonard to send on that second day after the incident. Walsh had been removed from field duties during the Inspector General's review, in a decision the agency had announced without explicitly connecting it to Leonard's lawsuit, but that occurred on a timeline that made any other causal connection impossible to construct credibly. The second agent had received an administrative assignment while the review was ongoing, and the entire operation had been suspended 4 weeks after the video had become public, in a decision the agency had described as protocol review, but that internal documents obtained during the discovery process would later show had been precipitated by the Inspector General's review's preliminary conclusion that the profiling criteria used in the operation were not defensible under federal anti-discrimination legislation applicable to immigration enforcement activities in American territory with a citizen population. The agreement was signed 11 months after that Thursday morning in the parking lot. Victor had conducted the negotiations with the specific patience of someone who knows that time is not working in the opposing party's favor, and that each additional week without resolution is a week in which the operation's internal documents remain as public record of the process, and in which the recording continues accumulating views and references in discussions about immigration policy that the agency would prefer not to be feeding. The agency had made 3 offers before the final agreement, each revealing through the amount offered the assessment it had made of the risk of going to trial with that body camera as central evidence and with the operation's profiling documents as established context. The first offer had been rejected by Victor without immediate counteroffer, with a note explaining that the amount demonstrated the agency had not yet made the correct assessment of what was at stake. The second had produced a counteroffer. The third had produced the agreement. The financial amount of the agreement remained partially confidential by negotiated clause, but sources familiar with the process confirmed it was among the largest ever paid by the agency in an individual civil rights violation case, and that there was an additional component that was not part of the principal amount, but had been included as a separate condition. The agency had agreed to pay the mental health treatment costs Leonard might require in connection with the documented effects of the incident, without value limit and without expiration date. a condition Victor had included in the negotiations after Leonard had described in one of their preparatory meetings what he had experienced in the weeks after the parking lot. The nights he had woken with the physical clarity of being back in that space with the bags in his hand and the agents around him. The specific difficulty of a man who had survived Vietnam and who had built decades of life after that, processing that the government of that country had questioned his right to exist in it in a grocery store parking lot on an ordinary morning. The institutional conditions of the agreement had been the longest to negotiate, and had been the ones Leonard had defended most firmly in every meeting with Victor about what was and was not negotiable. The operation that had produced the incident had been permanently closed, not suspended for a fixed period but closed, with formal closure documentation that had been included as an annex to the agreement and that existed as a verifiable record independently of any subsequent public statement by the agency. The profiling criteria that had been used in the operation had been formally designated as non-conforming with agency policy, a designation that had been inserted in the operations manual with specific language that made any future operation using similar criteria a documentable violation of internal policy beyond any external legal violation. Walsh had been dismissed as a condition of the agreement, with permanent notation in the employment record. The second agent had received a 6-month suspension without pay and had been required to complete a training program on the constitutional rights of American citizens in immigration enforcement operations. The condition that had been most contested in the negotiations, and that Leonard had told Victor, was the one he would not concede regardless of the impact on the financial amount, was the condition on specific veteran training. Leonard had demanded that the agency implement, as part of the agreement, a mandatory protocol that identified American Armed Forces veteran status as a factor that should be verified immediately in any citizenship verification approach, with a direct access mechanism to the Department of Veterans Affairs database that permitted real-time verification. That condition had met agency. Resistance that had argued operational complexity and interoperability issues between different agencies' systems. Leonard had told Victor, in one of the meetings where this had been discussed, that operational complexity was the argument of people who had not spent 14 months in Vietnam, and that interoperability between federal agency systems was a problem the American government had demonstrated it was capable of solving when it had decided the problem merited a solution. The protocol had been included in the agreement. The Inspector General's review had concluded independently of Leonard's lawsuit, although the two processes had shared evidence through the appropriate legal mechanisms that the operation had violated internal Department of Homeland Security guidelines on permissible target identification criteria in enforcement operations on American territory. That conclusion had been made public in a report that had cited Leonard's case, with his name as a central example, of the operational failure that had been identified, and had recommended systemic changes that went beyond the conditions of the individual agreement, and that had created a second level of pressure on the agency to implement changes the Leonard Agreement had established, but that the Inspector General's report had validated with the authority of an independent federal investigation. Leonard had given an interview after the agreement was signed, the only one he had granted throughout the entire process, to a journalist who had covered the case since the initial article that had described the recording. The interview had lasted 40 minutes and had been published at a length the journalist had justified to the editor by saying there were some stories that aggressive editing diminished rather than improved. Leonard had spoken about Vietnam with the economy of words of someone who had reached the conclusion that some experiences are not explainable but can be referenced. He had spoken about the 32 years of work and about retirement and about Thursdays at the grocery store with that folded list in his shirt pocket. He had spoken about the notebook where he had written the names and numbers that Thursday afternoon after putting away the groceries. And he had said, near the end of the interview, something the journalist had placed as the last sentence of the article because he had immediately recognized it was the sentence that contained everything the article had tried to say in the 42 preceding paragraphs. Leonard had said he had served that country because he had believed in what it represented, and that the process he had conducted had not been to prove he had served, because that was already proven in military documents that had existed for 50 years, but to demand that the country act in accordance with what it represented rather than merely representing it. He had paused after saying that. Then he had said he would return to the grocery store the following Thursday, that there were eggs on the list,
Sweetheart, who is this man to you?
He's my daddy.
She is my daughter, sir.
I didn't ask you. Is he telling you to say that, sweetheart?
No.
The candles were lit on the pancakes when the officer walked into the restaurant. They were 2 small candles, the kind you buy in a box of 20 in the party aisle at the supermarket, and they were planted on top of 2 stacks of pancakes at a red upholstered booth table at an IHOP in Ohio on a morning in October 2020. The girl beside the man was wearing a paper gold crown, the kind restaurants give to customers celebrating birthdays. And there was, at that table, the specific quality of a breakfast that had been planned in advance because it meant something. Because there was a child who had woken up that morning knowing it was her special day and that her father had promised pancakes with candles. That scene, a father and daughter celebrating a birthday at a restaurant on a weekday morning, would be interrupted by something neither of them had planned, and that the body camera of the officer who walked through the door would capture in enough detail for the entire world to see what had happened in that red upholstered booth. The body camera had been recording since before the officer entered the restaurant. It recorded everything, as body cameras do, without discriminating between what would matter and what would not, without knowing that that specific file would become one of the most watched videos of that month in that country. The timestamp in the upper right corner marked 10:51 in the morning. It was a Friday morning. The restaurant had the typical weekday IHOP traffic, a few tables occupied, staff circulating with coffee pots, the smell of pancake batter and maple syrup that is the specific smell of that kind of place. And there was, in that environment, in a booth near the window, a gray-bearded black man and a light-haired white girl with a gold crown on her head, celebrating something that had begun that morning as the kind of memory children carry for the rest of their lives. The man's name was Robert. He was 56 years old, had retired 2 years earlier after a career as a maintenance supervisor at a manufacturing company, and had adopted the girl beside him, whose name was Ayla, when she was 2 years old, after a process that had lasted 18 months and had involved home visits, psychological evaluations, court hearings, and all the steps the system places between a child and a permanent home. Ayla was turning 6 that October morning. Robert had promised her that the birthday breakfast would be special, had chosen IHOP, because Ayla had specifically requested pancakes and had arrived early enough to secure a good table before the weekend crowd. It was an ordinary Friday morning at an ordinary restaurant, and there was nothing in that scene that should have drawn anyone's attention beyond the 2 of them. Someone in the restaurant had called the emergency number. The call had described an adult black man with a small white child who appeared frightened and who was possibly being held against her will. That description, which the body camera and dispatch records would document with precision for subsequent analysis, had been made by someone who had looked at Robert and Ayla sitting in that booth, and had reached a conclusion about what they were seeing before verifying any fact, before asking anything, before considering any explanation beyond the one they had immediately constructed upon seeing a black man beside a white child. The conclusion had been kidnapping. And that conclusion had been enough for an officer to be dispatched to that IHOP that morning, with a narrative already formed about what they would find when they arrived. If this is your first time on this channel, welcome. What that body camera captured in that restaurant in Ohio is one of the most disturbing and most important recordings this channel has ever analyzed. Not for violence, because there is no physical violence in this story, but for what it reveals about the kind of assumption that can transform a birthday breakfast into a crime investigation. Hit subscribe right now and tell me in the comments. Can you imagine celebrating your child's birthday when an officer walks in and asks whether the child is being forced to stay with you? Tell me down below. The body camera captured the moment the officer arrived at Robert and Ayla's table with the candles still lit on the pancakes. It captured Robert's expression when he realized what was happening, an expression any parent would recognize as the expression of someone simultaneously understanding the personal danger of the situation and the need not to let that danger manifest in a way that frightens the child beside them. It captured Ayla's expression, who at 6 years old did not fully understand what was happening, but understood enough to know that something had changed in that morning that had begun with a promise of pancakes. And it captured, with enough clarity to be transcribed and analyzed by anyone watching the video, the officer bending down toward Ayla and asking, in that specific tone used with children, when adults want information they believe the child is being prevented from giving, whether the man beside her had told her to say what she was saying. Robert had arrived at the IHOP at 10:23 that morning, according to the restaurant's point-of-sale system record that documented the time the order had been placed. He had arrived holding hands with Ayla, had asked for the booth she had pointed to near the window because from there you could see the street and Ayla liked watching cars go by while she ate, and had asked the waiter for the birthday crown that the restaurant offered to customers who were celebrating. The waiter had brought the crown, had sung happy birthday along with a colleague who had been called over to join in, and had taken a photo of the two of them on Robert's phone at his request, a photo that existed on that phone at that moment, and that documented with a simplicity no legal document could replicate what that table represented that morning. 2 smiles, a gold crown, pancakes on the way. The person who had made the emergency call was sitting 3 tables away from Robert and Ayla. They had observed the two for several minutes before picking up the phone, according to what would be reconstructed subsequently through the statements of other witnesses who were in the restaurant that morning and who had paid attention to what had happened before the police arrived. None of those witnesses had observed anything they would describe as suspicious behavior on Robert's part, or any sign that Ayla was afraid or uncomfortable. What the witnesses described was a birthday breakfast, the crown, the pancakes, the waiter singing happy birthday. One specific witness, a woman who was sitting in the booth immediately behind Robert and Ayla's, said she had heard the conversation between the two for several minutes before the officer arrived, and that what she had heard was exactly what it appeared to be: a father answering a 6-year-old's questions about what she wanted to do after breakfast. The officer who had been dispatched was Detective Sergeant Kevin Collins. He had 15 years of service, had worked on crimes against children cases for 6 of those years, and had arrived at the IHOP with the call description in his ear and with the kind of focus that professionals with that specific background develop, a focus that is valuable when a real crime exists, but that can become an obstacle when the premise orienting it is wrong. Collins had entered the restaurant with 1 additional agent, had located Robert and Ayla at the window booth in less than 10 seconds, and had walked toward them, with the posture the body camera captured as the posture of someone approaching a situation they have already classified before arriving. The candles were still lit on the pancakes when he reached the table. Collins had addressed Robert first, asking his name and requesting identification. Robert had provided both without hesitation, had removed his wallet from his pocket with deliberately slow and visible movements, had shown his driver's license. Collins had examined the document and then had done something the body camera captured, and that would become one of the most analyzed moments of the video. He had turned to Ayla. He had crouched slightly to be at her level, had adopted that specific tone of voice adults use with children when they want to appear non-threatening while obtaining information, and had begun asking questions. He had asked her name. He had asked who the man beside her was. He had asked if she was okay. And then he had asked the question the camera captured, and that appeared in the caption of the image that would become the most shared of the entire case. He had asked whether the man had told her to say what she was saying. Ayla was 6 years old and was wearing a gold birthday crown, and there were pancakes with candles in front of her. She had answered Collins' questions with the specific directness of young children who have not yet developed the layer of social filtering that adults use to soften information. She had said her own name. She had said the man beside her was her father. She had said she was okay. And when Collins had asked the question about whether her father had told her to say that, Ayla had looked at him with that expression the camera captured in detail, and that anyone who has ever interacted with 6-year-olds would immediately recognize. The expression of someone who has received a question that makes no sense to them, and who is processing why an adult would be asking something so obviously unnecessary. She had answered no, that her father had not told her to say anything, that he was her real father, and that it was her birthday. Robert had remained still during that exchange between Collins and Ayla. The body camera captured him in the background during the questions directed at his daughter, and what it captured was a containment that went beyond ordinary self-control. It was the specific containment of a black father who understands that any movement he makes at that moment, any word he says without being asked, any emotional reaction that spills over, can be interpreted in a way that worsens a situation that had already reached a level it should never have reached. He had kept his hands visible on the table, had maintained a neutral expression in the way it is possible to maintain a neutral expression when what you really want to do is pick up your 6-year-old daughter and leave that restaurant as quickly as possible. He had waited, and the camera had recorded every second of that wait with the precise indifference of a device that does not know what it is documenting but documents anyway. Collins had continued asking Ayla questions for a few more minutes after her initial response. The body camera captured that sequence with a clarity that made audible not just the words but the tone of each exchange. And what the tone communicated was something that child interview specialists who later analyzed the video would describe as an approach that had been designed, probably without deliberate awareness on Collins' part, to produce a specific response rather than discover the truth. The questions were not open-ended. They were questions that contained premises, that assumed there was something to be uncovered beyond what Ayla had already said, that treated her responses as potentially unreliable for reasons that an adult's logic could construct, but that the actual experience of that child did not support. Ayla had answered every question with the same direct consistency with which she had answered the first, because the truth she was describing was the truth she knew, and that did not change regardless of how many times or in how many different ways someone asked. Robert had asked to speak at a certain point in the interaction, and Collins had raised his hand in a gesture the camera captured as the gesture of someone signaling that it was not Robert's turn, that the conversation at that moment was with the child and that he should wait. That gesture, of a police officer silencing a father while interrogating his 6-year-old daughter at a birthday table, had been captured by the camera with a clarity that several legal commentators would describe as the most revealing moment of the entire recording, because it concentrated in a single frame the entire imbalance of the situation. Robert had lowered his hand and had waited, and the camera had kept recording. The second agent who had arrived with Collins had been positioned in a way that Collins's camera captured in the background, and his position was the position of someone monitoring Robert while Collins conducted the interaction with Ayla. That division of attention, Collins focused on the child and the second agent monitoring Robert, was a configuration that made sense in a context where there was real reason to suspect immediate danger. But the pancakes were on the table. The crown was on Ayla's head. The waiter who had brought the crown and sung happy birthday was a few meters away and had been observed by both agents when they had entered the restaurant. There was a context in that booth that anyone arriving without formed premises would immediately recognize, and that context had been ignored in a way that the camera was documenting in real time. It was the restaurant manager who introduced the element that finally began moving the situation in a different direction. He had observed the interaction from the beginning, had initially been uncertain whether he should intervene, and had decided to approach when Collins had begun the third round of repeated questions to Ayla. The manager, a man in his mid-40s who had worked at that establishment for 12 years, had approached the table and had told Collins that he knew Robert, that he was a regular customer for years, that he came regularly with his daughter, and that there had never been any problem of any kind associated with their presence. He had said this with the specific calm of someone providing factual information they consider relevant, and who expects that information to be treated as such. Collins had listened, had thanked him for the information, and had continued with the interaction the way he had been conducting it before the manager's intervention. There were other customers in the restaurant who had been observing that scene from varying distances, and with expressions that the cameras on their own phones, which at least 3 of them had begun using discreetly since the situation had begun, captured as expressions of people who were watching something that disturbed them, but who were unsure whether they should intervene. That hesitation, which is understandable in a context where there is active police presence, had kept the other witnesses silent for a period that subsequent analysis of the timestamps of the individual recordings would estimate at approximately 8 minutes from Collins' arrival to the moment when one of the witnesses, a woman named Patricia, who had been sitting in the booth behind Robert and Ayla's since before any of the parties involved had arrived, had stood up and walked to the table. Patricia had stood up and had told Collins, with a firmness that the other customers' recordings captured with enough clarity to be transcribed, that she had arrived at the restaurant before Robert and Ayla, that she had observed everything from the beginning, that the child had arrived holding that man's hand, that both had been greeted by the waiter, who knew them by name, that she had watched the crown being placed on the girl's head and the candles being lit on the pancakes, and that what Collins was doing at that moment was not investigating a crime, but was ruining a 6-year-old child's birthday in front of that child. She had said that and then had stood there, waiting. Collins had looked at her, had looked at Robert, had looked at Ayla with the gold crown and the pancakes going cold on the table. And for the first time since he had entered that restaurant, Something in his posture had changed in a way the body camera captured, but for which there was no simple word to describe beyond belated recognition. Collins asked Robert to accompany him to the area near the restaurant entrance to speak separately, away from the table where Ayla had stayed with the second agent beside her. Robert had agreed, had said a few words to Ayla before standing up, words that Collins' camera had captured with audio clear enough to be transcribed. He had told her to stay still, that he would be back in a minute, that the pancakes would be there when he came back. Ayla had looked at her father with that expression the camera had captured, and that Patricia, the witness who had stood up, would later describe as the expression of a child who does not understand what is happening, but who trusts that her father will sort it out. The specific expression of someone who has been taught over 4 years of living together that when her father says he will be back in a minute, he comes back. Near the entrance area, away from Ayla, Collins had asked the question Robert had been expecting since the officer had arrived. At the table, he had asked Robert to prove he was the girl's father. Robert had returned to his wallet, had removed a laminated card he had been carrying since the adoption process had been finalized. The adoption decree in a reduced format that attorneys who work with adoption sometimes recommend that adoptive parents of children with different phenotypic appearance from themselves carry in situations of public movement. That card existed because Robert had been advised by the attorney who had processed the adoption that situations like that one were not unlikely, that the specific combination of a black father and a white daughter in public spaces generated a kind of attention that documentation helped manage. He had heard that advice, had thought it was the kind of unnecessary precaution he hoped never to need, and had carried the card anyway because the attorney had been persuasive, and because deep down he had understood that the attorney was right. Collins had examined the document, had verified the names, had verified the date, had verified the judicial process number that was recorded on the card and that was verifiable in the court system. The examination had taken perhaps 2 minutes, during which Robert had stood with his hands visible and his gaze going periodically toward Ayla, who was visible from where they were at the table he had left, with the second agent beside her. When Collins had finished examining the document, he had paused before returning it in a way the camera captured as the pause of someone processing the distance between the narrative they had brought to the restaurant and the reality they had found. He had returned the card without immediate comment on its contents, and then he had said he needed to verify the document in the system before he could release Robert. That verification had taken 11 minutes. 11 minutes during which Robert had stood in an area near the entrance of an IHOP on a Friday morning while his 6-year-old daughter waited at a birthday booth table with a police officer beside her and cooling pancakes and candles that had already gone out. Other customers who came and went from the restaurant during those 11 minutes passed by Robert and the scene with those expressions that the phone recordings of those still inside the restaurant kept capturing in the background. The manager had returned behind the counter, but had kept his gaze in the direction of the situation. Patricia had returned to her booth, but had kept her phone in her hand, and Collins' body camera had kept recording everything, including every minute of those 11 in which Robert had stood, waiting for a system to confirm what a judicial document had already established. The verification had returned positive. The adoption decree was legitimate. The judicial process existed in the court records. Robert was legally Ayla's father, with all the rights and responsibilities that designation created under Ohio law. Collins had communicated that confirmation to Robert in language the camera captured as the language of someone who is technically acknowledging a fact without fully recognizing the implications of what that fact meant in relation to everything that had happened in the previous 23 minutes. He had said that everything was in order, that Robert was free to return to the table, and had added, almost as a postscript, that he was sorry for the inconvenience. That word, inconvenience, used to describe 23 minutes of interrogation of a father and his 6-year-old daughter at a birthday table based exclusively on the assumption that a black man could not be the father of a white child, was captured by the camera with the same fidelity with which it had captured every other word that morning. Robert had returned to the table where Ayla was waiting. Collins's camera had captured that return. Robert sitting back down in the booth, Ayla looking at her father with that expression that had been on her face the entire time he had been away. Robert had looked at the pancakes that were cold now, had looked at the candles that had gone out, had looked at the gold crown on his daughter's head that was still there because Ayla had not taken it off, and he had said something to her that the camera captured, but that the audio had not fully preserved, only the last words, which were the words any father would say in a situation like that. One, and which were also in the reading of anyone who watched the video, knowing what had happened in those 23 minutes, the most devastating words of the entire morning. He had said that everything was okay, that Daddy was here, that they could still have the birthday breakfast. The video reached the public in a way Robert had not planned and had initially not wanted. He had left the IHOP that morning with Ayla, had returned home, had tried to salvage what remained of that birthday with a second celebration attempt in the backyard with cake and the presents he had saved for that afternoon. He had put Ayla to bed that night, with the crown still on the bedside table because she had asked to keep it, and had sat in the kitchen after she fell asleep, processing that morning with the specific quality of silence that exists when an experience has been too large to fully process at the moment it happened. He had called the attorney who had handled the adoption process at 10 that night. The attorney had answered, had listened to the account, and had said 3 things in sequence that Robert would later describe as the 3 sentences that had changed the direction of what would happen next. He had said that what Robert had described was illegal. He had said there was a body camera that had recorded everything, and he had said that Robert needed to decide what he wanted to do with that. Robert had asked for time to think. It had taken 5 days. During those 5 days, he had spoken with his sister, had spoken with a close friend who was a university professor, and who had experience thinking about questions of race and justice in a way Robert trusted, and had had a conversation with Ayla that had been the most difficult of the 3 because it involved trying to explain to a 6-year-old, in language a 6-year-old could process, why that morning had happened the way it had happened. Ayla had asked the question 6-year-olds ask when they do not understand something. She had asked why the police officer had thought her father was not her real father. Robert had been silent for a moment before responding. He had said that sometimes people see 2 people together and make assumptions about them before asking anything, and that those assumptions are sometimes wrong. Ayla had processed that for a few seconds, and then had asked whether the officer had apologized. Robert had said yes, that he had said he was sorry for the inconvenience. Ayla had looked at her father with that direct 6-year-old expression, and had said that was not a real apology. Robert had agreed that it was not. The decision to make the video public had been made on the 5th day, after the attorney had explained that the request for the recording needed to be made within a specific time frame, and that waiting longer created the risk of the material being overwritten or lost before it could be formally preserved. Robert had authorized the request. The recording had arrived through the appropriate legal channels. The attorney had watched the complete video, had identified the most relevant moments for a potential lawsuit, and had made a second call to Robert in which he had said that the recording was clearer than he had expected, that it documented every moment of the interaction in a way that made the reconstruction of the facts practically automatic, and that there was a strategic decision to be made about whether to release the video publicly before or after filing a formal lawsuit. Robert had chosen to release it first because he had reached the conclusion during those 5 days of processing that what had happened at that IHOP had not happened only to him, and that the utility of the video went beyond the individual lawsuit that might result from it. The video had been published on a sharing platform with a factual description of what had happened, without inflammatory language, without asking for anything specific beyond that people watch it. In 48 hours, it had accumulated more than 8 million views. The specific combination of elements in the recording, the birthday, the gold crown, the pancakes with candles, the officer's question to the 6-year-old about whether her father had told her to say what she was saying had created a resonance that transcended political and demographic divisions, that normally fragmented the audience in cases of police discrimination. There was no available ambiguity in that video, in the way there was ambiguity in other cases. There was a child with a birthday crown, and there were cooling pancakes, and there was a police officer asking whether the father had instructed his daughter to lie. The outrage had been broad, immediate, and had come from directions the police department had not anticipated when it had issued its first statement trying to frame the incident as standard procedure in response to an emergency call. The department had attempted, in the days following the publication of the video, to build a public defense based on the narrative that Collins had responded appropriately to a legitimate call and had followed standard verification protocol. That narrative had collapsed in multiple and simultaneous ways. First, because the video showed Collins continuing to question Ayla even after she had responded consistently, and even after the manager had provided additional context, which was inconsistent with any reasonable verification protocol. Second, because the existence of the adoption decree in portable format, which Robert had carried specifically because of the attorney's advice about situations like that one, made the 11-minute verification difficult to justify as necessary rather than punitive. And third, because Patricia and at least 2 other witnesses had given voluntary statements confirming what the camera showed and adding context about what had been observable in the restaurant from before Collins's arrival. Context that made it impossible to argue that any reasonable basis for initial suspicion had existed. Collins had been removed from field duties while the internal investigation was ongoing. In a decision the department had announced with standard language about commitment to accountability and transparency. The police union had issued a statement of support for Collins that had been received with a reaction the union itself had clearly not anticipated, because the statement had used the language of operational discretion in response to a legitimate call in a context where the video made that language audible in a way that caused it to sound like a defense of something that most people who had watched the video did not consider defensible. The platforms where the video had circulated had transformed that union statement into the second most shared element of the case after the original recording, creating a juxtaposition between institutional language and the body camera images that was more effective as criticism than any additional commentary could have been. The lawsuit was filed in federal court 8 weeks after that birthday breakfast. It was a 96-page document that had been constructed with a structure that experienced attorneys in the field described as one of the most complete they had seen in cases of racial discrimination involving children, because it operated in layers that reinforced each other in a way that closed practically every exit that the defense normally uses in these cases. The first layer established the racial discrimination directly, documented by the body camera that showed the approach without observable justification and by the absence of any behavior by Robert or Ayla that could have motivated the call beyond the racial combination that had been perceived by whoever had called. The second layer argued violation of Robert's constitutional rights, specifically the protection against detention without probable cause, documented by the fact that the 11 minutes of verification had occurred after a judicial document had been presented, and its validity established before any call to the system. The third layer was the most legally innovative and was the one legal commentators had discussed with most attention. It argued specific harm to the child, that Ayla had been subjected to an interrogation conducted by a state agent during which she had been questioned in ways that presumed her father could be a criminal, and that harm was documentable and compensable independently of the harms suffered by Robert. That third layer had been constructed with the assistance of a psychologist specializing in child development and trauma, who had evaluated Ayla in the weeks after the incident and had produced a report documenting the observable effects of that morning on her behavior in the subsequent days. The report described specific changes that the psychologist had attributed, with documented clinical basis, to the experience of having her father separated from her by state agents in a situation she had perceived as threatening without fully understanding why. There were nightmares in the 3 days following the incident. There was a reluctance to accompany her father to public places that had lasted approximately 2 weeks. There were repeated questions about whether her father could be taken away again. None of those effects had been permanent, and the psychologist had documented Ayla's gradual recovery with the same precision with which he had documented the initial effects. But the documentation of the existence of those effects, even if temporary, had created a clinical basis for allegations of harm to the child that made the lawsuit significantly more complex than it would have been if only the harms to Robert were considered. The department had attempted, through its attorneys, to persuade the court that Collins had acted within the limits of qualified immunity because he had responded to an emergency call and had followed what he considered reasonable procedure given the circumstances. That defense had encountered an obstacle that would become central in every preliminary hearing. The body camera showed Collins arriving at the restaurant, locating Robert and Ayla in less than 10 seconds, and walking directly toward them without making any additional observation of the environment, without checking with any employee before approaching, without considering any alternative hypothesis to the one he had brought from the car. That behavior of someone who had arrived with a conclusion and was implementing that conclusion without the evaluationist step the law required before any action that restricted someone's freedom was precisely the behavior that the qualified immunity doctrine did not protect when there was clear evidence that established rights had been violated. The person who had made the original call to the emergency number had been identified through call records during the discovery process. She was a 63-year-old woman who had been sitting at a table 3 booths away from Robert and Ayla. She had been contacted by Robert's attorney as part of the process, had initially refused to answer questions, and had subsequently given a statement through her own attorney that was, in Robert's attorney's assessment, the most direct admission available of how the assumption had functioned. She had said she had seen the girl appear quiet and had become concerned. When asked whether the girl had seemed frightened or in danger in any specific way, she had said not exactly, that it was more of a feeling. When asked whether she had spoken with anyone in the restaurant before calling, she had said no. When asked whether she had considered that the man might be the girl's father, she had been silent for a moment before saying she had not thought of that. That statement, that she had not thought of it, was the most precise description available of the mechanism that had set everything in motion, an assumption, formed so quickly and with such certainty that the most obvious and most common possibility that an adult man accompanying a child in a restaurant might simply be her father had not made it to consideration. Collins was dismissed 5 months after the incident, after the internal investigation concluded that he had conducted the interaction in a way that violated departmental approach protocols and had prolonged Robert's detention beyond what any reasonable justification could sustain after the adoption and documentation had been presented. The union attempted the appeal it always attempts, and the appeal was denied with language the arbitrator had chosen with enough precision to be cited in civil rights organization statements in the weeks that followed. Language that said the body camera had documented not a misjudgment, but a sequence of consecutive decisions, each of which had had an available exit point and none of which had been taken. The agreement that closed the lawsuit was announced 7 months after that birthday breakfast. The financial amount was kept partially confidential, but sources close to the proceedings confirmed it was among the largest ever paid by the county in civil rights cases involving children. The non-financial conditions included complete revision of response protocols for calls involving minors, mandatory training on racial bias and on adoptive and foster families with phenotypically mixed compositions, and the creation of a review mechanism for false calls that had resulted in illegal detention, with the possibility of referral to the prosecutor's office when the discriminatory element could be established. That last condition had been the most difficult to negotiate, and had been the one Robert had defended most firmly, because he had understood from the beginning that the call that had set everything in motion had not been made by Collins, but by someone who had looked at a birthday table and had seen something that did not exist, and that as long as there were no consequences for that kind of call, the cycle that had produced that morning would continue reproducing itself in other restaurants at other tables with other fathers and other children. Robert had returned to the same IHOP with Ayla 2 months after the agreement was signed. He had chosen that restaurant deliberately, had asked for the same window booth table, had ordered the same pancakes, and had brought 2 new candles he had put in his bag before leaving home. The manager who had tried to intervene on that October morning had recognized Robert when he walked in, had walked to the table, had shaken Robert's hand, and had said something that Robert would later describe as the simplest and most necessary thing anyone had said to him throughout that entire process. The manager had said, "Welcome back." Robert had sat in the booth with Ayla, had asked the waiter for the candles, had lit both on a stack of pancakes, and had looked at his daughter. With the crown she had insisted on wearing again, because it was the same crown from last time, and she had said the birthday was not over yet. This time, the candles stayed lit until Ayla blew them out. This time, nobody walked through the door.
Equity is an ongoing path, and information is your greatest armor. We appreciate your viewership and dedication to undeniable truth.